I do not take cases. I consult on cases, and I'm an expert witness, but I do not take cases. All of the referrals, and there are many of them, that come from my blog, I give for free to lawyers who merely indicate their willingness to accept these cases and represent people competently. I take no referral fee, I take no co-counsel fee, I take nothing. There are two reasons. One, I'm on a mission here, I don't need to be doing this at all. Two, I don't want to be responsible for another lawyer's work. So I don't want to be his partner. Which underscores what I just said. Interview, get references, and so forth. The final risk of that is on you. Even if they're on my list, on my blog, it doesn't mean that I'm giving you a guarantee as to their work. You probably need a lawyer now, whereas a year ago you could do more of this as a pro se litigant. The issues are starting to get more complicated, and they're moving in the direction, I believe and I predict, that they are moving in the direction of a serious constitutional question of due process under the 5th and 14th Amendment. This is not something, folks, that you can do yourselves. All right? Nor are judges very excited to hear somebody even bring the subject up. They would rather do anything than decide a case on constitutional grounds. But as I see what's been happening, especially in California, with that little game they play with the unlawful detainer, and you never get a chance to be heard in court. Whether you're right or wrong is not the question. You never get an evidentiary hearing, and in fact, in most cases, you never get more than about 6 words out of your mouth before the rubber stamp comes down. That's a denial of due process access to courts, which is guaranteed by the United States Constitution under the 5th and 14th Amendment.
What about Arizona? They do the same thing there?
They're doing it in a lot of states. In addition, as applied, I don't like the non-judicial process to begin with. But given the fact that it is presumptively valid under some circumstances, I do not believe that non-judicial sale is an appropriate remedy or even an available remedy in a securitized loan. And you'll see why when you see how many stakeholders suddenly pop up in the securitization chain and how their claims conflict with each other. There is no way on earth that those claims can be resolved in a non-judicial sale, which means that the moment you signed your deed of trust, you had a cloud on your title, and there was a cloud on title for anybody subsequent who took it, whether it was in foreclosure or not. So we have a mess there. And the only way that is ever resolved is judicially. That means in court, where a judge hears evidence, makes a decision on the evidence, enters an order. I will tell you that it is still true, for those alumni who remember a year ago, I said, look, chances are, once you present a credible threat to them, they will walk away. That appears to still be the case. However, the threshold for a credible threat has gone up a lot. They're pushing you more to the wall. But in the last few months, I know of many cases, every one of them reported to me under confidentiality, because they're still pinching themselves, where they got a default final judgment quieting title to them. That means they had a mortgage, they don't now. They had a note, they don't now. They own the house free and clear, including one not too far from here with a $2.6 million loan that doesn't exist anymore. Okay? It's still true that they will let the case go by default, but I'm not saying or predicting that this will always be the case. It could start today or tomorrow that they start pushing this. But here's why it's happening the way it is. They are doing anything they can to avoid an evidentiary hearing. They're doing anything they can to avoid an appeal. Because if they lose one case, if any of them lose one case, they've lost all the cases for all of them. The stakes couldn't be higher for them. So they will use every means to intimidate you. They will use every means to fool you. For example, those of you who follow the blog probably noticed that I had a piece that I did not too long ago on modification fraud. Modification fraud is the rule, not the exception. Modification fraud consists of you calling up saying, look, in one case, for example, I can offer you a 20% loan to value, which means 80% equity, but I need a change in the terms. And them saying, okay, send the forms in, and now pay this amount, now pay that amount. They pay $12,000 to them and all that. And them calling up, asking how we doing. Oh, we didn't get the papers. They send it in again. And them following up and asking what their status is. And, oh, we didn't get the papers. They send it in again. And then they're told everything is okay. Yeah, everything is okay. Knock, knock, knock on their front door. Hi, I'm the new owner of your home. Get out. Okay? That's modification fraud. Why? Because they need not a modification, they need a default. And the reason they need a default is that they have insurance for defaults. They don't have any insurance for modifications. And get this. Imagine if you could insure your house against fire for the full value, and then you could buy another 30 policies just like it. They call that leverage. They insured those pools that they knew were going to fail because they created them to fail. They insured those pools 30 times over. So if you had a $300,000 mortgage, courtesy of the U.S. government to AIG and AMBAC, they were paid off $9 million on a $300,000 mortgage.